Hi, everybody. Thanks for tuning in. We appreciate it. Tim Andersen here, the Appraiser's Advocate. And we're here today with Craig Capilla. Now, you probably know Craig. He's all over the internet. He is an attorney. He started out with the Illinois, Craig, you started out with the Illinois board prosecuting appraisers and brokers and stuff like that, right?
That's correct.
And then you did that for a few years, and then you left the dark side and came over to righteousness, and now you defend appraisers in front of those boards. And you do that primarily in Illinois and Wisconsin, if I recall correctly. But through your contacts, you're able to work with appraisers all over the country, correct?
That's correct, guys. So I'm coming back up on about almost 10 years of being back out in private practice since I left the state of Illinois. My licensing is in Illinois and Wisconsin and several federal districts. And though we do actually get involved and appear in matters all over the country at this point, either affiliating with local counsel in some other circumstances, up until the point it goes actually to litigation. Sometimes we can just correspond and interact directly with the regulators and that sort of thing. We also have a little bit more of an expanded footprint in the federal circuits anyway. So we're in a handful of states. As of this moment, I'm probably in 10 or 12 different states working on whether it be appraisal litigation files or other matters. We're probably 10 or 12 different states at this time that I'm working in right now.
Craig, thank you. And you and I have worked together in the past, working with appraisers who were brought up before their state boards. And before we get into Austin v. Miller, which is the purpose of this podcast today, give us a précis, if you would, of the services you provide for appraisers and how you can help them.
Oh, fantastic. Actually, I'm always happy to kind of give the menu. So most frequently when my phone rings, I always joke, nobody ever calls me when they're having a good day. It's the problem has transpired, and now they are trying to sort that mess out. So they've received the nastygram in the mail or in their email box from their state regulator. You have 17 minutes, transmit this report and work file to us immediately, or something along those lines. More frequently nowadays, unfortunately, it's a letter from HUD or the state's Human Rights Commission or something along those lines that you've been accused of bias and discrimination. Immediately send us that report and work file and answer these questions and all that sort of thing. So that's the sort of phone call that I frequently receive. However, we do have a handful of clients who are a little bit more in what I like to call the preventative medicine bucket, which is we have for a number of years helped appraisers, appraisal firms, and we're not just limited to that. It's real estate brokers and brokerages. And we do work with appraisal management companies. We do work with lenders, small banks and the like. Work on compliance solutions as well. So everything from corporate establishment, corporate governance, if you're a small business and you're trying to get that part set up and you're trying to have your documents and corporate formation aspects in line, all the way through helping folks make sure they're compliant with their particular state license law and regulations and everything else in between. But again, when my phone rings, it's typically because the problem has already occurred and somebody is now looking to address that problem. So whether it's a state license board action, whether it's a malpractice claim that is either looking at a court case or an arbitration or something like that, interacting with the insurer to make sure that the claim is tendered properly or addressed. And we do even have a segment of our practice where the claim may not be accepted. It may, in fact, be denied for some reason by the insurer. We will get involved and try to assist the policyholder, the E&O person, to obtain coverage from their carrier as well. So we really try to be kind of a full service package for small business owners, really. And that dovetails a lot with licensed professionals generally. But again, the sorts of things that I end up getting brought out to talk about and all that are usually once the problem's already occurred, and how do we put that back in the box? And that's always the challenge to these things.
All right, good. Craig, thank you. And I can see from the background that occasionally you do birthday parties and weddings and stuff like that with your guitars, right?
Exactly,
Just on the
and
side.
I make a wonderful giraffe out of balloons as well. So
Okay, so you're a complete 360 guy. Okay, good deal. All right, now, all seriousness aside, let's go to Austin v. Miller. Okay, now, this is a lawsuit from the Austins against Miller and Miller's appraisal firm, and then the AMC who hired Miller to appraise Austin's house. So, because I'm not an attorney and will probably get lost in the details, why don't you explain to us from a legal standpoint what's going on here, and then I'll ask some questions about it from an appraisal standpoint. So go ahead and explain to us what's going on in Austin v. Miller, if you would, please.
absolutely. So that case filing in particular really sent shockwaves, and so one of the things that I'm going to try to keep our focus on as we discuss this case today is, unlike in the past, when I believe you and I have discussed several kind of bellwether cases on appraiser liability, and I think we've touched on matters of like reliance and third-party reliance on the appraisal report and all that sort of stuff. And I've spoken about that with some other folks as well. Had these conversations with Peter Christensen before, where we talked to folks about this case holding and that. This is uncharted territory because this is active and pending litigation. This is a complaint that was filed in just December of last year. This case is 2 months old, which in the litigation chain is this baby hasn't even come home from the hospital yet. This is uncharted territory for all of us. The other thing that's of tremendous significance with the Miller case here is I'm not going to say it's absolutely the first of its kind, but this is really the first noteworthy appraiser bias and discrimination case. And so in this matter, a couple in Northern California in the Bay Area, the Austins, along with an organization called the Fair Housing Advocates of Northern California, are appearing as plaintiffs in this lawsuit, and they have filed the lawsuit against the individual appraiser and the appraisal firm, and also the appraisal management company that ordered the appraisal. And the theory of the case in the complaint, as stated by the plaintiffs, is that the appraiser undervalued their property, and the reason for the undervaluation was bias and or discrimination. And the claim itself is set out over a variety of counts in the complaint, with basically violations of applicable fair housing laws, state and federal. And that's something that you folks also need to be aware of, is this is not a purely federal question or a purely state question. There is overlap between state and federal law on these. And so, federal law obviously is consistent no matter where you are, but different states have different versions of their own state enacted and enforced fair housing laws. And so there may be more lawsuits like this later, but they may take on different flavors at a certain point, depending upon what state they're in. And finally, and we're not going to touch on this point too much, but it's a clever part, is there is also an additional count in this complaint that speaks to, or it's possible that the appraiser in this matter was just really negligent about everything. And that's a significant component that it seems like an outlier, because it seems contradictory to, you had preconceived notions and a bias against me, which is why you arrived at the conclusions you did. or you were just really sloppy and negligent about it. Those things don't seem to, those don't coalesce very well. But it's a very significant component of this complaint, because that argument that there may have been negligence involved is actually what's keeping, or I shouldn't say it as certain as I am, but it's going a long way towards keeping errors and omissions coverage in place to defend and indemnify the defendants on this one. The typical errors and omissions policy will not cover intentional acts. So if you're accused of bias and discrimination, if you're accused of fraud or conspiracy, and unfortunately, I've seen all these before. I've litigated these concerns where the appraiser suddenly finds themselves without coverage in a case because the complaining party, oh, you were in it and you were in cahoots with the bank to do XYZ to the value of these properties. And so that was fraud and that was collusion. And, or I was a whistleblower and I turned you in for being in cahoots with the bank. And so that's a false claims action. None of that's covered by your errors and omissions insurance. Intentional acts are neither an error or omission. They're intentional. And so they don't fall under that umbrella of coverage. This is a weird quirk that probably isn't getting enough press, but the fact that this complaint also includes a claim of, or maybe you were just inadvertently wrong, keeps the insurance coverage pot available for recovery. So that was a bit of a tangent on that aspect of it, but I don't know that part's getting enough discussion because that's very important. That's right now what's preserving coverage for the appraiser and the AMC. Not that the insurance companies are looking to stick anyone on this. Yeah, I've had some conversations with some of the brokers at this point that are out in the market space selling errors and omissions insurance. Obviously, they're all watching this very closely, but they're all very concerned what might be happening to their appraisers that they provide coverage for. So it's not that there's an immediate break or anything on that. But again, this is one aspect of it where, in this case, there should be coverage available for all of the defendants because of the way the case was pled.
Given the fact that the plaintiffs have set this up in this manner, they're not doing it for the benefit of the appraiser. They're doing it to make sure that somewhere along the line there is a pocket into which it might be possible to reach. Am I being too cynical, or is that more or less correct?
No, I think that's exactly the right interpretation. Because what you'll notice again from the alignment of the plaintiffs in this matter is you have the husband and wife, borrowers, homeowners who are acting as the plaintiff. It's their particular property, their particular loan application. And then you also have the advocacy group that has aligned with them and joined as co-plaintiffs. And that's another thing that's going to seem out of the ordinary to the average reader who doesn't spend a lot of time in this litigation. I can tell you that when it comes to fair housing concerns and discrimination matters, that is an extremely common circumstance that there are, I'd venture to say, in just about every major urban area and a variety of others, they're just spread a little bit more thin. There are these sorts of consumer advocacy groups that exist to try to root out fair housing violations, housing discrimination, and the like. Their most common application in all of these things, I mean, bluntly, it's leasing discrimination. It's more often landlord-tenant concerns, and it's this particular landlord wouldn't rent to that particular tenant because race, sex, creed, all of that, any of the protected classifications and or a variety of others. It's subject to Section 8 housing vouchers. And, oh, I don't know, you must not have a steady income, so I'm not going to rent my apartment to you. And there are a variety of laws that prevent that say, yes, the federal government's money is just as good, or the state's money is just as good as a private employer's money, and XYZ. That's typically what these advocacy groups are set up for. That also means that they are more savvy in developing their theory of the case and applying it. In this instance, I don't believe we'll go to the heart of the complaint at this point. We'll kind of circle it back around. There's a variety of counts in the complaint, and they do detail substantively the appraiser did this, the appraiser did that, the appraiser did this, the appraiser did that, the appraiser should have done this, the appraiser should have done that. In essence, what it boils down to is here's a particular appraisal report on a particular property, and here are the steps the individual took. But also, here's the problem with the entire process. They were focusing on these sales. They should have looked at these sales, that kind of a thing. I am fairly confident the Austins were not sitting around their kitchen table one day thinking, you know what the biggest problem is? We've really been damaged here and we've been harmed because that gosh darn sales comparison approach just doesn't do the right thing, and we should do something about that. That's a tailor-made argument that's coming from the advocacy group that has been exploring this for a while. They've been studying up on it, they've been learning it, and they've been waiting for this fact pattern to appear and to come through the door. Just like knowing that if we also plead a negligence count in the alternative, that's going to keep coverage of the defendant parties preserved in all of this. So if we do get to the point of attaching liability and we can start looking at an award of damages, we have that proverbial pot of gold at the end of the litigation rainbow in place, because their insurance carriers can't deny coverage, disavow the claim, and now we're stuck trying to collect from an individual or a business that might go dark. All of that is the inherent advantage in finding a consumer advocacy group to review the substance of the case, take it in, say, yes, we'll help you, we'll work on this with you. And you know what? We're going to join right alongside you, and we'll walk down this path with you. So that's how that sort of thing arises. It is a savvy complaint in that respect. There's a couple of telltale points within it that indicate this is the complaint process. The path for this has been under consideration for quite some time. It was a matter of, are the correct facts, is the scenario going to appear that we can then lay over the structure that we've created to approach this issue?
Okay, so basically what you're saying is, yes, the Austins believe that they have been wronged, but there apparently is an undercurrent, an underflavor, if you would, that one of the co-plaintiffs has been looking for an opportunity to bring this to the fore. This opportunity presented itself, and now they're taking advantage of it. So am I correct in that, or am I being too much of an appraiser in developing that theory?
No, I don't think you're being too much of an appraiser at all. I'll put it this way. I think the theory of the case has been around, or it's been under development for quite a while. It's also part of the reason why I do not believe for a second this is the only one of its kind that we're going to see in this manner. And in fact, I've got reason to believe that we will be seeing more like this and not too far down the road. Again, just as the bias and discrimination issue started to work its way to the forefront again, and we had a Washington Post article, and we had a New York Times article, and we had, I think it was a Denver Post article, and that almost crafted a playbook of, here are the concerns we're seeing, here are some steps that can be taken. And in the wake of those articles running, you started to see a significant uptick in complaints to HUD, to a state human rights commission, and to the state license board, making those same sorts of allegations of bias and discrimination. I think this complaint framework for litigation is it's the front. of this next wave, we will see more complaints styled like this one. And yeah, in essence, I think the advocacy group has likely, along with a number of their colleagues, I don't think it's limited to this one particular group in Northern California. I suspect there's been conversations about, here's problems we're seeing about home valuation, and we know that there is this discrimination in valuation. We just know it's there. How would we go about trying to fix it when it comes in our door? And this is the approach to that in written form. This is the draft that has come out of it. I think we'll see this pop up in other jurisdictions with some modification. Again, it's going to be of a different flavor on occasion, because not all of the state law claims are going to be applicable everywhere, and there may be, as this particular case takes twists and turns, I'm sure the successor cases in other areas will wisen up and either attempt to cure any defects that may exist before they file, or alternatively, they may prepare offshoot theories to react to expected defenses and that sort of thing. One of the things it's a recent development in all of this is a motion to dismiss by the defendants is on file in this case. That's going to be informative as well, because that's a first glimpse at how do the defending parties push back and poke holes in the claims of the plaintiffs in this case. We're all going to have to sit back and watch and see how that turns out. And are these defenses asserted? Are these statements that the plaintiffs are wrong and that they don't have a claim that they can proceed on, or that this isn't what they think it is and they're not going to be able to prove it, or whatever the substance of the motions to dismiss are. And because it's an active case matter, I'm not really going to go into the weeds of what the various approaches of all of this are. We're going to have to sit back and watch to see what happens next with the first thrust of the defense case theory. And is that going to carry any weight? And are they going to be able to knock out some or all of these claims? So the next 60 to 90 days in this case are going to be quite interesting, because we'll, at least on the front end, we'll find out, was the complaint that's been drafted and put on file by the plaintiffs, is that complaint sufficient? And if it's not sufficient, is that curable, or is it an incurable deficiency? And this is just kind of for folks that have never been in the litigation chain in any way, shape, or form. I commend you, stay that way. But for those of us that play in the sandbox, this is the sort of stuff that we're looking for, which is the first thing that happens is you've got the complaint that goes on file, and it's the statement of the case by the aggrieved party, the plaintiffs. We've been harmed. Here's why we've been harmed. Here's why this harm violates a particular law or a policy. This is the relief that we're seeking, that we're entitled to by law or policy. Please give us what we're asking for. That's the genesis of a legal form complaint. The motion to dismiss phase, which is almost an automatic at this point, and there are very few cases we ever get engaged in that we don't file a motion to dismiss. We don't always expect that the motion to dismiss is going to eliminate the case entirely. That happens almost never. It's very infrequent that a motion to dismiss will terminate a case. But what it does is it forces the plaintiffs to narrow the scope of their complaint and refine their argument. There are circumstances where we can knock something out of the box entirely, and now it's dead and gone and it's never to return. And that's great. And we want as much of that as we can. But it's just as important to force the plaintiffs to begin narrowly tailoring what their argument is, what their position is, because that makes it easier to defend against in the long run. And so that's a bit of what you're seeing here in the motion to dismiss that's now on file. Is it going to be ultimately successful and end the case? It may be. We don't know that yet. We won't know until there's motion, response, reply, argument in front of the court, and then the court can rule on the merits of those relative positions. It's extremely likely that there will be some modification or some amendment to the complaint based on the issues raised in the motion to dismiss. Does that mean the complaint's going to go away entirely? Maybe, maybe not, probably not. But at the very least, it should continue to rein in the complaint a bit. And then we'll watch as this case proceeds from there. We'll watch the path it takes. But so from that end of things, for the law nerds in this is a particularly fascinating and active time, because there's a lot that can change here in the next 60, 90, 120 days. It sort of depends how loaded up that court docket is in Northern California. But we should get some better sense of what is this case going to look like going forward once we get through this motion to dismiss phase.
You talked about narrowing the focus of the case. Again, I'm not an attorney, so help me out if I've got my analysis complete backwards. In reading through the complaint itself, to me, the essence appears to be that the plaintiffs are upset that the defendant valued their property via the sales comparison approach. Their claim is that had they done so via another approach, the value probably would have been higher. Or if the defendant had expanded the scope of search for comparable sales, that the value opinion might have been different, meaning higher. So is the sales comparison approach what is under attack here, or is it appraisal in general that is under attack here?
That's a great question. First of all, you nailed it. That is the aspect of this case that I think merits the discussion. Unlike any other appraiser liability case that I'm aware of the multitude that we've worked on at our firm, that we've consulted with other folks, that appraiser defense attorneys stand around the water cooler and chat about, as if that were actually a thing. It's always an appraisal on a property, and the appraiser must have done XYZ, or the appraiser should have done XYZ, but this wasn't really their best day, so here we are. We're used to seeing those cases. The garden variety negligence, negligent misrepresentation, and I've seen it crafted in all manner. So I've seen good arguments by a plaintiff. I've seen bad arguments by a plaintiff. And bluntly, sometimes it's a garbage case and the plaintiff is just barking up the wrong tree and there's nowhere to go there. And other times, from the moment that thing walks into your door, you're looking at it going, ooh, that appraiser really wishes they could have that day to do over again. I mean, it happens. You get that. And frankly, we've all been there. I mean, the whole point of negligence arguments are like, I know we're not looking at your best work product. You probably wish you could hit the do-over button and restart this one. Perhaps some mistakes were made. That is in fact the theory of negligence. So that happens, and we've seen those things. This case is different. At first blush, I don't know that everybody recognized that. That was, oh my, this is an appraiser who's now being sued, and this is an appraisal management company who's now being sued for bias and discrimination. That's new. That's different. Okay. That underlying cause for me doesn't move the needle very much. What does move the needle for me, and what makes this one, I think, incredibly significant, is my read, and to your point, sort of how you have read it at this point, is it's not the appraiser and the appraisal management company that are being accused of wrongdoing here. It's that the appraisal process is being put on trial, and they're being represented in physical form by the appraiser and the appraisal management company. Right now, in this case, the appraiser and the AMC are the pioneers that get the arrows for the rest of the profession. And it is exactly that it is the sales comparison approach that is being subjected to court scrutiny here. That is a novel concept. Where this goes is it is going to change the face of this industry. Is valuation, is appraising as a whole on trial? I don't know that yet, but I would question, can you separate the sales comparison approach from the entire rest of the valuation body? And does it live if you have removed that leg? I don't know. Look, I'm not going to go the whole doomsday route here. There's absolutely going to be valuation of things going forward, and there's going to be compensation to adjust the path of the valuation process as needed. It's not just going to evaporate overnight, but is it going to look a whole heck of a lot differently in 2, 5, 8, 10 years as a result of this case or companion cases or whatever? Actually, for the first time in a long time, I will tell you, yes, I think that's a very real possibility, that we're going to wake up someday down the road, not too far down the road, and this whole process is going to look a bit different. What's the answer to that? I don't know. But I do think this is going to have significant impact on how the question of valuation is solved going forward.
All right, let me pursue this a little bit further. So, given what we've seen in this complaint, which may be followed up by other complaints, in fact, it probably will be followed up by other complaints. The sales comparison approach, or let's generalize it, the appraisal process itself appears to be under attack. Now, let's discuss the appraisal process itself from the standpoint of what you do as a defense attorney. So in this particular case, the defendant, now again, I've not seen the appraisal report. I don't know, but it's possible that given the fact that the property under appraisal was an existing property, the appraiser chose to investigate value simply by the sales comparison approach, which is typically what we do. Would it help the appraiser in the future? And I'm not saying would it have helped the defendant, that's not the issue. But in the future, would it help the appraiser to avoid situations such as this one? If the appraiser were to engage in all three approaches to value, and then instead of giving all weight to the sales comparison approach, give appropriate weight to the sales comparison approach?
I think the answer to that question is a great question. I think the answer to that question is certainly going to be on a case-by-case, assignment-by-assignment basis. I mean, if we want to get into the appraisal process that certainly the average consumer does not understand, is not equipped to process, and based on the sorts of work that you and I do, we could reasonably question whether all of the appraisers out there understand this process as well. We know that the appraiser in an assignment must consider the three approaches to value, essentially. I mean, that's just at a bare minimum. You got to do it. You have to consider them. Now, for the average residential lending assignment on a 1-unit parcel, all right, I have the assignment in the door. I have now just completed my consideration of the three approaches to value. I'm going to go start looking at sales. Okay, I get it. That is the typical consideration of all three approaches. I know how that goes. We all know how that works. Should we maybe be devoting a little bit more time to actually considering the applicability of those approaches? Sure. I think there's quite a bit of merit in that. We were supposed to be doing that anyway. It's not just because somebody filed a lawsuit in California. It is part of the job. Now, going into actually the analysis and then the reporting on the assignment. So now let's get out of the scope part and let's dive into 1 and 2. Yeah, let's see where it fits.
You mean UPEP 1 and 2, right?
That's correct. Into USPAP standards 1 and 2. Let's go ahead and actually, I mean, USPAP is not a checklist, but if you were to keep the binder open next to you, you sort of could proceed point by point through. I'm just throwing that out there as a suggestion. And so as a result, you can sort of see the appraisal process laid out for any particular assignment. And so whether this is a smallish bungalow on a postage stamp sized lot in a particular urban neighborhood, or whether this is some enormous tower with X number of units, or whether this is so many acres located out in whatever, the process is the same. The amount of care and the amount of consideration to each step in the process will change according to the specifics of the assignment, but the process never changes. So yes, let's consider whether solely the sales comparison approach is appropriate here, or whether first obvious choice is, does the cost approach apply here, in that it can yield a credible opinion of value? Now, that's the first hurdle the appraiser is going to run into. This is the age-old question. Does the validity of a cost approach to value opinion lose its efficacy at 5 years of the property's age, 10 years of the property? When does it become too hard to separate out depreciation to yield a credible value conclusion for the cost approach? I don't know the answer to that question. I suspect there is no bright line answer to that question, because it's been argued about since the approach was first created. But is there some merit to running a cost approach? And I've said this since the beginning. I will continue to say this until I'm done doing this bit. If you're going to do an approach and you're going to complete it, you do have to do it correctly. You can't go ahead and fashion up some numbers to back your way into a cost approach value and say, see, I did the cost approach. It doesn't do you any good. It didn't tell you anything to begin with, and it's not helping find where you might have some problems in your sales comparison approach. The other one, income approach, certainly is going to be the least likely solution here, just because for the majority of the properties we're looking at, where these sorts of issues are going to arise, they're typically not income generating properties. So you're likely not going to have a vast pool of other income generating properties as a data set that you can analyze and yield any sort of a credible conclusion from. But, should you at least pull the curtain back a little bit, scratch the surface on that idea and see if it might work? Sure. Because even in the worst case scenario, you've got no income approach comparables to use. So that one's really going to fall by the wayside. So your best bet is a little bit of a shaky cost approach, because you've got all sorts of concerns with depreciation. And then you've got relative sales that you can work with in the area that, again, everybody knows the best comp is the cookie cutter house right next door that's a mirror image of yours and it sold yesterday, and we never get to use that one as a comparison. You're never going to find that clean of data in a sales comparison either. But if you do that and you put a cost approach next to it and they come in pretty close, maybe you're on the right track. If you do the sales comparison approach, you do a cost approach, and they're vastly different, you have to ask yourself, did I do the cost approach right? Did I do the sales comparison approach right? Can I identify in my own work where I might have been off or made a wrong assumption or conclusion? Because if I can't reconcile those two, there's that word, reconciliation. If I can't reconcile those two, this thing's not ready to go out the door yet. I have to understand how these two numbers can exist and whether or not they should be bringing me closer together and they should be more in alignment, or if not, why not, and how do I explain that? Great. Everything I just explained to you creates a significant problem in what is the typical residential mortgage lending assignment right now where we would like you, appraiser, to accept this assignment. And if you could get it back to us by lunchtime, that would be swell.
I like that analogy. Thank you. Greg, you mentioned due care, which I'm going to expand to due diligence. And then you mentioned reconciliation. Now, tell me if I've got this wrong. Basically, what you were saying is sales comparison approach. Okay, we typically use that for houses. All right, no, I don't think anybody has a problem with that. But what you're saying is rather than just invest 100% of the time in the sales comparison approach and just blow the others off as useless, what you're saying is do the sales comparison approach. But then the other two approaches, and maybe not the income approach, because that doesn't apply most of the time, but at least the cost approach, you're using that as an indication of due diligence. Because what you're saying is, okay, I'm going to come up with a number via the sales comparison approach, and then I'm going to test it via the cost approach. And assuming all the numbers are right, I haven't made any math errors, et cetera, then if they're not close to one another, and I don't know what close means, but if they're not close to one another, then I've got some more analysis to do to find out, number one, why, and number two, even if should they really be close. And then you raise the issue of lunchtime. So the appraiser says, well, I've only got 24 hours and 48 hours to turn this puppy around. So I think what you're saying, and again, correct me if I've got this wrong, I think what you're saying is, okay, appraiser, maybe you're going to have to build a little more time into your process so that insofar as possible, that you have touched every salient, relevant point. Therefore, when you conclude a value, it is based not only on the appraiser's 30 years experience, but it is also based on market-derived, market-tested, and market supporting facts. Is that a reasonable conclusion to make?
That's absolutely correct. And look, I get the realities versus the ideals, right? We know what the environment is today for appraisers. It's not easy. This is not a cakewalk of a gig. But what I will always caution people about is, look, USPAP, that thing we all have to keep going back to. USPAP talks about time, doesn't it? It talks about marketing time, it talks about exposing time. It doesn't talk about turn times. USPAP doesn't change because of the shortened time frame the appraiser has to complete a given assignment. USPAP doesn't care how long you have. USPAP requires that the process be completed and that the reporting be adequate. Yeah, there's a lot more to this than just relying on, well, I had to turn it around right now this afternoon, or I had to get it out by tomorrow morning, right? All of those things might be true. And if you're unable to comply with all of the requirements and also meet that criteria, maybe you can't perform the assignment. I have had throughout my career countless appraisers sitting in my office, or in these COVID times, sitting through a computer screen. And I will tell you, the one statement that I have heard with the utmost frequency, more so than anything else, it's not about a square footage adjustment. It's not about how much is that extra half bath work or how much is that fireplace worth. Bar none, number one with a bullet, there is no second place. I really wish I wouldn't have taken that assignment. That is the most common statement I have heard throughout my career. Folks, there's a reason why that one comes up over and over again. It's always the one you were a little unsure of. It's always the one, I might be able to squeeze this in. It's there. I don't want to walk away from work. I don't want to do that. When the spidey sense tingles a little bit about, can I get this? Can I do this? That's the one that jumps up and bites everyone. And that continues time and again. And I think if I just had to guess, I have no real basis. This is pure speculation. But if I had to guess, a number of the reports that are now coming up in the context of bias and discrimination are reports where the appraiser perhaps had a sense something's a little bit off. I can't quite put my finger on it. I'm not really sure here. No big deal. I can get it done. I'll take care of it. Because what I'm actually seeing as a common thread throughout the complaints, and again, I've not had one that has gone to litigation at this point, but I've dealt with HUD rather extensively. I've dealt with state regulators, either license boards or human rights commissions, those sorts of things. The common thread that I'm seeing throughout those kinds of complaints is a borrower who truly believes they have been done wrong for whatever reason. That aspect of it will vary on a case-to-case basis. But you've got a borrower who truly believes they've been done wrong, and an appraiser who didn't see that coming because this was just another report, and I did this like I do all of my other reports. And that's where the communication breakdown happens, because the appraiser may have been writing that report for a lender that they've been doing work for 30 years. I know Jed down at the so-and-so credit union, and I've been doing work for them my entire career. They knew what I meant. Okay, great. But what you've got now is a borrower who has failed expectations. They didn't get their refinance, or they didn't get their front end, whatever the case may be. And why didn't I get it? Well, it didn't come in at value. Well, let me see that thing. And then they start going through going, well, I know this neighborhood and I know that area. Why was it that house that mine was compared to? I know mine is better than that house because I have this, I have that, I have this. Does that necessarily mean that gives it more market value? It does in their mind, even if the market doesn't support that. The average consumer, the average borrower, doesn't know the appraisal process. They're not educated in that. So they're sitting here going, well, why didn't I get credit for this with my house? Why was it that house? I know them. They've been there. They never cut their grass. That house sucks. Why was it compared to that? Those sorts of questions. And they can't find an answer in the report itself. There's a couple of reasons for that. The report isn't designed for them, especially since we switched over to the UAD. Do you want someone sitting around their coffee table trying to figure out why they're a C4? The consumer is not equipped to do that. So that it's in Sanskrit to them to begin with. So the things they can attach to is, this appraiser must have had something against me because I know my property and it was better than that one. I hate to say it, it's a natural reaction. I don't like it, but I do think most of the complaining parties in this come into it with a genuine concern, and the appraisers are already playing from behind the eight ball because of the formatting we're using. And then the next phase is, how well did you explain your work? And then, what was it, a couple of months ago now, a month, 2, 3, some reporting came out about language still contained within appraisal reports that have just gone under kind of a survey of, let's see what's out there. And you start seeing descriptions of the neighborhoods where it's talking about racial characteristics of racial makeup of the neighborhood, and it caters to this particular ethnic group. And I mean, that, for the consumer that doesn't understand how to do regression analysis, suddenly talking about what people look like in my neighborhood sort of sends up a red flag. The appraisal profession does have some deep thinking to do here on how to cure some of these issues. I don't necessarily think bias and discrimination are really at play in a lot of these cases, but conversely, if I'm somebody who didn't get the loan that I thought I was going to get, and I'm starting to read some of these words and see some of the considerations made, I can see how that leap is being made to, well, they clearly had something against me. And that's the gap that I think we need to figure out how to bridge.
Craig, thank you. Your remark about some deep thinking that has to go on is true. I completely agree with you. And that's something you and I will address at a future time. But yeah, that we've got to sit down and say, okay, we can't have 80,000 people, 80,000 appraisers doing this differently. We got to get on basically the same bandwagon. And so far we haven't, but that's another issue entirely. So, Craig, again, please let me thank you. Let me thank you for your expertise, for your time, for your great guitar collection, and the fact that you are the fact that you're so willing to help out appraisers, especially when they get that letter and don't know where to go, don't know who to turn to, and it's great to know that it's possible to pick up the phone or send an email and get help. If someone needed your services, how could they most easily get in touch with you?
All right. So the easiest way to get in touch with me, there's a couple of different ways. If you go to our website, so the firm, since last we spoke, there was a little bit of an evolution in all of this. Well, actually, you and I have spoken more recently, but since the last time we did a video or an interview like this, a podcast, there has been a little bit of a change. For any number of years, 8 or 9 of them, I was with what was called the Franklin Law Group. As of last year in 2021, early 2021, we actually threw a couple of law firms into a blender and came out with a whole new organization. So it's now Franklin, Greenswag, Shannon, and Capilla is the law firm. There's 9 of us working out of the firm at this point. If you go to fgcclaw.com, so you'll find all of us. So, obviously, if anybody ever has any questions or concerns, consider us a resource. We're happy to help. If we can help you, we will. If we can't, we will try to point you in the right direction to get you in touch with the people who can help. If you would like to contact me directly, there are a couple of ways to do that. My email address is my first initial and last name. So ccapilla, CCAPILLA at fgcclaw.com. Or you can call us at 847-701-2250. That's the main switchboard to our office, and then the call gets directed my way. Or if you feel like speaking with someone else in the office, I assure you, they're all friendly. They're all happy to take your call. But no, if we can ever be of assistance, that's what we're here for. We're a resource. There are any number of opportunities we've had to help folks, and we're always open and appreciative of that. There are also a number of circumstances where we've had to say, hey, we're not what you're looking for, but we can get you there. And please don't hesitate to reach out and we'll get you directed. Our goal is to put you in the direction you need to be headed, whether that's us or somebody else. So by all means, Tim, thanks for having me. I appreciate you doing this. I appreciate you having taken the time and having me come on. And if anybody has any questions or concerns, please don't ever hesitate to reach out, and we'll be happy to help however we can.
And Craig, you typically attend the many of the national appraisal conferences, so you're available for consultation there, as I recall, having seen you at most of them the last couple of years. Yeah,
that is true.
Okay, excellent. Craig, again, I thank you. Appraisers, thank you. We appreciate what you do for us as well as what you do for the industry. And please let me extend my personal best to you and your family. I look forward to the next time we get together.
Absolutely. Tim, thank you so much for having me.
All right, everybody. Thanks. We're glad you're here, and we're clear.